I thank you everyone for joining us for Special Education Hot Topics 2023-2024 school year on Wednesday, September 27th with Jennifer Bradley and Heidi Goldsmith with Bradley and Goldsmith's Law. Our disclaimer: the ARC of Lehigh Northampton County's Advocacy Department does not employ lawyers nor provide legal advice. This training or any others provided by the ARC's Advocacy Department does not constitute or imply the endorsement, recommendations, or favoring of the providing party or any other employees or contractors acting on its behalf. This webinar is being provided for educational and informative purposes only. Thank you for letting me share that. And with that, I would like to introduce Heidi and Jennifer from Bradley and Goldsmith. The Zoom is yours.
All right, Jen, do you want to start us off with introductions, or did you want me to do that?
Yep, I'm going to share our PowerPoint. I think it's up there now, right?
Yep, I see it.
All right, good evening, everyone. Thank you for joining us here today. My name is Jennifer Bradley, and my partner is Heidi Goldsmith. I hate to say how long Heidi and I go back, but it's a long time since law school. We both went to Villanova together, graduated together. I'm not telling you the year. And then Heidi ended up joining a private law firm doing special education, and I ended up doing some criminal law. I was a prosecutor in Berks County for quite some time until Heidi poached me into the world of special education. I would say back in 2007. And we've worked together since 2007, first at a private firm, and then 5 years ago, actually, our 5-year anniversary is coming up. We decided to go out on our own and join forces and develop our own firm to basically advocate and support students with children with disabilities through the state of Pennsylvania. So not only do we do advocacy, but when parents find themselves in a situation where they need counsel to help support them through due process hearings or whatever may unravel through the special education process, we do that. And we also do trainings like this. We do a lot of parent trainings. Before COVID, we actually used to do in-person IEP clinics. But we do work with a lot of organizations around the state of Pennsylvania to just help provide guidance. The law is always changing. The law itself, I would say, the IDEA really hasn't changed, but there's been case law. And of course, the Pennsylvania Department of Education has changed things. So it's always being decided in a different way. So that's what we're here tonight to do, is talk about some of the hot topics that are going on right now. And for once, it's not COVID. So with that, I will move to the next slide, if I know how. So we're going to be getting into the hot topics, but what we have to remember is what the goal of special education is. And it's not just for the state of Pennsylvania, it's for the entire country, because it's a federal statute. So this federal statute is applicable through the country. And the goal of that statute is to ensure that students who attend public school systems receive a free, appropriate public education. And that acronym, of course, is FAPE, and you'll see that all through probably these slides. But if you kids who are in special education, or if you're a professional, FAPE is a very common acronym. Special education is filled with acronyms, and that's one of the main ones. And what exactly is FAPE? Well, there's certainly a lot of case law that defines FAPE, and it can vary essentially from state to state. But in general, FAPE, what's required of FAPE is for children with disabilities from ages birth to 21. They're entitled to a program that's reasonably calculated to provide that child with meaningful educational progress in all domains. And when we say all domains, we're not just talking about academics. We're talking about social, emotional, behavioral, and physical. So when we're looking at these cases and these students, the students may have straight A's, but may have some social or emotional issues. Doesn't mean that child is not entitled to services to help support them. And there's been a lot of case law too about what's considered meaningful under the IDEA. And we've gotten some direction from the courts. And in general, we like to say it's not we use the analogy for cars. It's not that car that doesn't work and it's up on blocks and doesn't have an engine, but it's also, not the Lexus or the Beamer. It's kind of somewhere in the middle. So, and it has to be that the program has to be meaningful in light of that child's potential. So those are some of the things that we take into consideration. And this year in Pennsylvania threw us for a little loop because they changed the age to 21. Typically, the IDEA states that children from birth to 21 are entitled to services, and this is what we've been used to, where birth to 3 services are covered by the Office of Child Development and Early Learning. And then when kiddos turn 3, usually goes to the intermediate unit, and then at age 5, it goes to or 6, whenever the child enrolls in school, it goes to the local school district. And it typically had been through the school year in which that child turned 21. So if that child turned 21 December 1st, that child was entitled to services through the end of that school year, including extended school year services. That's changed. We found out at the end of the summer that the state was extending FAPE eligibility until age 21. And here's where I'm going to turn it over to Heidi.
So, and Jen kind of briefly touched upon the history, but it kind of is important to understand the history of this kind of 3 to 21 age time period when you moved to Part B of IDEA. So again, Jen and I, you can add up probably some math somewhere that we've been around for a while, since she said, we've been practicing for a long time, and she just joined the firm, in 2000 or 2007. But, it used to be in the old days that when a child turned 21, like the day you turned 21, if it was the second day of school, that's when you got exited. And really the experience is this didn't make a lot of sense for kids with disabilities, right? It made more sense because they had entitlement to 21 to allow them to at least finish out the school year. And so then the rule kind of changed to, okay, once you turn 21, you're going to be able to finish out the school year. And then, there was other discussion in a couple of years ago, and it might be longer, it feels like a couple of years ago. They then now said, you know what, really, if you're saying to 21, that includes the summertime period, and it extended into the summertime periods. Some districts still didn't believe it. To this day, I think some districts didn't believe it, but the reality is PDE said it. Now, one of the things that's always important to understand is this is not state law. And the reason why this is important to understand is that there's a lawsuit now that was created, this entitlement to age 22 was created as a result of a settlement agreement between PDE and complaining parties, but it's binding on all districts. But there is also now a lawsuit basically saying, you've exceeded your governmental authority or regulatory authority, and this is really stuff that has to be created by state legislators. And it really is, as Jen likes to say, COVID's over, but the lessons and how things were handled still exist. So I'm sure we all remember there was a lot of lawsuits that said state government and agencies were creating rules regarding masking and rules regarding closures. And people were saying, no, you can't do that. This is the legislative authority. So there is a pending lawsuit right now that has been filed that is basically saying, this is stuff that has to be created to the state legislator. That being said, my vast experience is in speaking with any attorney for the district that they're going forward with it and acting as if that's not quote unquote on appeal, so they don't have to do it. Most districts are going forward. So what does that mean at this moment in time? And this is where, as a lawyer, I give you my big asterisk that what this means now. And it's the same one that I kind of gave when we talked about COVID masking. This is the rules regarding age 22 as it stands at this moment. I can almost guarantee, given my experience with PDE and because of this other lawsuit, we're going to get more guidance and different guidance as time goes on. So just bear in mind what you are being told today is this moment in time. But right now, PDE and what they did actually is, before even alerting districts that this occurred, and this is straight out of someone very high in authority, they had already sent letters of entitlement to students with disabilities who had turned 21 and had been exited prior to even districts knowing about this responsibility. Like, districts found out about their responsibility and that these letters had gone out at a mass meeting, apparently where PDE had turned off all commenting on the Zoom, so that no one could even ask any questions about that. So the reality is that all parents who this should impact should have received notices. But as of September 5th, that entitlement to FAPE until they have turned the day before they turn 22 exists. What does that mean in practicality? Now, I am a lawyer, Jen is a lawyer, and we both like to say we went to law school to avoid math. So we're going to make this real simple. So let's say you turn 21 on October 1st, 2023. That means you are entitled to FAPE to September 30th, 2022. And so now the question is, well, okay, but what if my child's exited last year, at the end of the summer? I'm just finding out about this. I'm not sure if I want something, what if and my child doesn't turn 22 till May, let's say it's May 30th. Do I have to enroll now? Because if we remember back when the state legislator created laws, not this past year, but the previous 2 years, that said you can get an extra year of education. You had these very tight time frames where you had to re-enroll students. As of this moment, there is no deadlines for re-enrollment. I will just tell you, as someone who has watched PD in practice for a long period of time, and given the fact that they're getting a lot of pushbacks from districts, I suspect there will be timelines put in at some point in time. Like I would, if I'm just reading my crystal special education balls, but I would suspect PD will eventually put in that you have, 60 days past turning of 21 or the exiting the previous school year to alert them. Because what the fear is that, let's say you have that May 30th date, suddenly the parents come back, May 5th or, April 30th to create a program. Now districts are trying to run around. They're going to have these sporadic situations of drop-ins through the year. You're also going to have situations of how long it takes. There is no regs right now, and that's a question was going to be asked. Once you notice the district, hey, I want programming, how long do they have? Well, let's look at that. There's no guidance. So first of all, there's no legal authority on it. So we have to use, again, the crystal ball of special education. What do we think likely the result's going to be? So first, PDE has made it clear that you are eligible for services as of September 5th. So that's our starting mark, right? September 5th, 2023. Now, if we look at things like during the lens of how we would look at this for COVID, when districts became aware that they had ongoing legal responsibilities to offer FAPE, basically everyone thought everything got closed down, but then the federal government back said people may be closed down, but the right to FAPE has not ended. So we look at it through a lens of what happened and when districts ran into problems of that during this current situation. And we're going to talk about like right now. So let's say you're noticed November 5th, your kid doesn't turn 22 to May 30th. Is it a situation where, or turn, whatever the situation is, turned 21, whatever point in time, and I'm again using round figures here, they're going to give them some leeway. And it's a matter of what did the district do and when did they do it? If you contact the district September 6th and ask for programming, is it a situation for their failure to maybe get a program together within the first 2 weeks? Probably not going to be hit too hard for that. But if it bleeds into like 3 weeks or 4 weeks or a longer time period, yes. And I think what's going to happen is there's going to be more rules and regulations as it goes around it. But it's going to be is it's kind of COVID. If the districts did nothing and said, well, we can't do anything, things are closed, hearing officers really got on top of them. If districts were trying and making good faith efforts, the hearing officers really didn't, do that much. And so it's kind of one of those reasonable man situations of what was the district doing to try to get a programming together? How much did the kid miss? What did the kid miss? And I would suspect there's going to be, unfortunately, not an indecent amount of kids, because usually at that point in time, kids at that age aren't just able to be dropped into high school programs. They're not just like, hey, come to school. Sure, you can start your learning support up again. These kids were, in IU run programs, creative programs with community-based supports and services. So creating those programs are going to have to be a little bit more tricky. And again, it's going to be something how to navigate. But in terms of legal situations, yes. My advice is when and if you are a parent who's experiencing this, what you should be doing is right off the gate say, we understand that this might take some time to set up. So we are entitled to some level of compensation for that. So how can we add more programming into the time period once we get the programming? So kind of utilize your little bit of negotiating room to try to get more right off the gate, where you've already acknowledged it, you know what's going to happen, and if there's a plan in place of how to address it. You can say that, like, you can be part of the program for every day the program's not set up. The district agrees to provide X amount of hours or additional supports of job training or whatever that situation is that can happen. But if the district is dragging its feet, you know, you are on a ticking time clock. And when I tell you that, that bell will ring, you know, the 21st day and 364th day of the year. And you need to be making sure you're also keeping track of everything. And you know, we always generally give this advice, but it's definitely important in this, which is you need to be documenting it. So if someone from the district calls you and tells you something, you need to be sending out, as I call it, the oatmeal pie. And I got asked about that recently because I always thought that was a great example. And someone said, I don't understand why you use oatmeal pie, because basically the sweet stuff is at the beginning, the end, and the, you know, the not so sweet stuff is in the middle, because the point is you say, thank you so much for talking to me today. I understand programming won't be set up. You don't have anybody available to implement the programming. Please let me know how the district plans to address this situation so that they're, you know, receiving the full benefit of this additional time period. And then again, appreciate all your hard work. But that's the part that you're really trying to document, which is, and again, in a very nice way, so people are sandwiching in it, you know, an oatmeal pie, you think you're kind of getting a healthy situation when you're really eating, like, you know, sugar and butter mixed together in the center. The question has also come up about ESY eligibility. And again, right now, PDE is taking a very hard line rule, which is the day before you turn 22, that's it. Now, there are some districts who may extend it out. There may be districts who candidly also read the PD tea leaves and say, last time they said there was a hard and fast rule, they extended it out, so we might as well extend it out now so they don't get whacked at a later date. But again, right now, that is not clear. That may change as well. Here's the fundamental problem, though, and it's just something that it's never good to unilaterally exit kids just one day off the bat, right? So it's like today, and especially kids, and let's just be candid, we're dealing with this situation, probably the most vulnerable part of our population. They're the ones who needed FAPE the longest. And so one of the things that we do all need to be working with kids with disabilities is if there is a situation where there is not a natural ending point, that kind of everybody is ending, it's the last day of school, it's the last day at ESY. If we're doing it on a natural time period, and you have a child who's, you know, is going to have difficulty with transition or difficulty understanding it, that now needs to be part of transition planning. So when we're talking about that part of the IEP, when we're discussing transition planning, that now needs to include, especially for kids who are going to be exiting at normal time periods of transition, that there's plans in place. Are they going to be able to say goodbye to everybody? Is there going to be some level ceremony for them? Are they going to get a certificate? You know, what is that kind of the end of that process look like? Because it can't be for some kids, because it can be really hard. Just, oh, tomorrow you're not coming back tomorrow. I mean, think about the kids with COVID. That can be a really difficult transition. So make sure you're transition planning, especially for the kids that are vulnerable for that additional change. And Jen, I didn't know if you had any additional thoughts you had on it, but again, I said, but again, just FYI, this is today. These could change 2 weeks from now, and there is a lawsuit pending.
PDE did give of course, in true fashion, they didn't give a ton of guidance, but they did give some that, you know, there have been questions submitted to PDE, and some of the questions are, well, does the IEP for a student who's coming back to school, who's re-enrolling at age 22, does their IEP need to be revised? And the general answer is the student is entitled to a FAPE. So if that student's IEP needs to be revised because the student's program is changing, or the team needs to meet to discuss goals or to discuss progress monitoring, then the answer is yes, IEP teams need to meet. And in general, my guess is most students who are in re-enrolling, this is all very new. Many of them have been exited last year. So there's going to need to be goals developed again, and a team meeting to discuss, okay, you're re-enrolling, and as a parent, what services are you truly looking for? Are you looking for an extension of the services that were occurring the year before? Or are you looking for something different? So the reality is IEP team meetings most likely should occur for students who are re-enrolling through 22. And then there's been other questions submitted to PDE about evaluations, reevaluations. Well, the IDEA again hasn't changed. These are just regulations that change within Pennsylvania. So if a student would be due for either a 2-year or a 3-year evaluation during the time that student is 22 and going to school, then that reevaluation needs to take place. So again, when a student is entitled to a FAPE under the IDEA, and that's what PDE is telling us, they're now entitled for an additional, could be a year, or could be less, but whatever that student needs to receive a FAPE, the school districts are required to provide that. So if it's a reevaluation, an IEP team meeting, changes in placement and so forth, different goals, then that needs to take place. And then I think there were also some questions too about the age restrictions, and those two have not changed. The age, the chapter 14 has age restrictions, so we're not putting 22-year-olds with 15-year-olds. And again, those restrictions can be waived, but they need to be appropriate and done through the IEP team. So that's another thing I think that's probably causing some difficulty for the districts, is students who are returning who are age 22 and maybe in some classrooms with younger kids, 17 years old. So there were the only other things that I wanted to touch upon. And I will then move on to, if I can, there we go. The next topic we were going to, and I'm sure we'll have questions about that, so we can answer those at the end after we're done recording. So I'm going to take over here and talk about the new consent forms that are coming down the pipeline. Of course, I have effective 11/2, but I think they might be effective the 11/1. I might have that date wrong. But there are new consent forms that have been developed. We are used to the prior written notice for a reevaluation or for an evaluation, and that form, the traditional form that we're used to, they're taking that form away and doing away with that altogether, and they're creating 2 new forms. There's a prior written notice for a reevaluation, and there's a request for consent for a reevaluation. They are 2 different forms. So the first form, the prior written notice for evaluation, is and I'll show them to you in a second here. This form, I'll actually do that now. The parent does not need to consent to this evaluation. I have it up here. So this is the prior written notice for a reevaluation. And this form is issued when, the IDEA regulations require for a reevaluation to be completed before the district either initiates a change in identification or a change of placement, or refuses to change the identification or change in placement of a student. So this is going to become a little tricky I think more so for the districts. So this form, the prior written notice for a reevaluation, is issued to the parents. The school district or the LEA is required to at least document the date that it was sent, and they need to complete this form and provide it to the parent. The parent does not need to actually consent and return this form. And what happens is once this document is issued, the district then gathers data and reviews the data that's currently available. If the team determines that more data is needed, then the district would issue the next form, which is the request for a consent for a reevaluation, which is actually much like the prior written notice that we're used to seeing. So the request for the reevaluation, a lot of times the district will issue that prior written notice to the family, the consent form, and they'll just do under there, if the parents aren't really paying attention to what the district is doing, a lot of times we'll just say review of records. It doesn't say the assessment they're not necessarily doing any assessments. And a lot of times parents don't pick up on that. So the parent would sign that document, return it, and then the district would have 60 days basically just to review the current data that's available and not complete any new assessments. With this new process, the district has to review the data. And if a parent requests an evaluation, the district has to issue this consent form. Or if the team determines that more data is necessary, then this form that you see in front of you, this is the form then that would need to be issued to the parents. And the district then has 60 days to do the evaluation. So it becomes tricky with the timelines because This doesn't change the timelines. If a student is due for his or her 2-year evaluation, it must be completed within that 2 years. And if new data is needed, it has to be done by that deadline. So if the district is delaying issuing that first evaluation request form, the prior written notice for the reevaluation, and determines it needs new data, they might be, and they only issue it with 60 days prior to the evaluation is due, they might be shrinking their timelines. So really, the request for a reevaluation really needs to take place well before 60 days before the student is due for their 2-year evaluation or 3-year evaluation. There's no set timeline for the previous form. So I can go back to that. Yeah. So this is the previous form. This is the request for the reevaluation. The only thing that is required of this document, the prior written notice for a reevaluation, it is the IDEA regulations that a reevaluation needs to be prior written notice must be given to parents within a reasonable time frame. So reasonable in Pennsylvania has been basically been calculated as 10 days. So the district will issue this form to the parent. And then after 10 days from the date of issuance, it should start reviewing that data. However, if the parent sends the form back or contacts the school and says, request that reevaluation, then they have 60 days to do that evaluation. Or if the team determines that they need more data, they have to issue that consent form. So really this process needs to begin before that timeline. So I know that it seems a little confusing on how it's done, but it's really going to be more confusing on the school district's part because and they need to basically initiate that well in advance because they're not changing the timelines. So once this form that you're looking at is signed, this part of it, the team needs to basically determine, do I have enough data? And if I do, then that reevaluation needs to be completed by either, if you have a child who is intellectually disabled, that needs to be done every 2 years. If you have a child under any of the disability categories, then that evaluation needs to be completed every 3 years. If the team determines that more data is needed, then they issue the next form, or if the parent requests it, and then they have to go through and complete the additional assessments. So this form is somewhat similar to the prior written notice that we were used to. They're supposed to be listing the assessments that are being completed. What's a little bit different is where the parent signs, which is on page 2 of this document, and it gives you additional options before you can just request an informal meeting, or you could disagree and request mediation or due process. But on this form in PDE's Infinite Wisdom, they decided to add an additional option to have an informal meeting, or not consent and have an informal meeting. So there's really no significant difference. Option 1, if you'd like to schedule an informal meeting with the school to discuss the plan, that's essentially saying, I don't agree or disagree, I just need more information. So if you want more information on what's going to happen or why the district is proposing certain assessments, you would check that box. However, if you don't give consent and you want to have a meeting before going to mediation or before going to due process, you would check box 3. You do not give consent, and then you would request the informal meeting there. And that's just essentially telling the school either I just need more information, or I don't consent and I want to meet and talk about it. So that's a little bit of a change with the form. And then the last form is just for the signatures. I would assume this form will probably have other pages added to it. Most districts have, some additional resources for parents. So this form itself is 3 pages, but most of your consent forms, they will have some resources for parents. So it might not exactly look like this. So what does that mean going forward? I know there may be some questions about the waiver form. Some school districts still propose to waive a reevaluation. They cannot do that if you have a child with an intellectual disability. It is not permitted. School districts must do an evaluation of a student with an intellectual disability. But if a school district believes that they don't need to review the data of a child and complete a reevaluation, a triennial evaluation, school districts are still permitted to issue that waiver form, which I don't have up here, but that hasn't changed. So they can issue the waiver to the parent, asking the parent to waive their right to a reevaluation. Of course, we as attorneys always say, don't do that. Have the reevaluation, even if it's just to review data and get some teacher, some teacher input and parent input added to it, or some updated observations. We always recommend not waiving it, but school districts are still permitted to issue the waiver form. If they receive a signed waiver form back from the family or the parents, the school district does not have to issue the request for a reevaluation or a consent form. However, if the family receives the waiver form and does not return it, the school districts are then required to issue the reevaluation consent form, plus or minus the other prior written notice form. So that's just a little bit of information on the 2 new forms that are coming out. And we should start seeing them. It's my understanding some districts are doing them. I haven't seen any yet. I haven't had any questions about it in my practice. But a lot of times by the time parents come to me, they've kind of been battling with the district for a while. So since this form is only coming out in a little over a month, we really haven't seen much of it. So we can take questions on that at the end. I know there's
Can I talk a little bit about that too?
Sure.
So here's the thing. You always have to ask yourself why. Why is PD doing this? Why is this situation? And, I hate to look for snakes under the grass, but let's be candid. This is an attempt, and it just really is. It's an attempt to put more burdens on the parents and get more loopholes for districts. Here's why. So one of the things that's happening, and it's really happening in our practice a lot, is districts are doing really cruddy evaluations because of the fact that COVID has hit. A lot of kids are now struggling a lot harder. So they're under this pressure to do all these evaluations or be on notice to do evaluations. And then they do the evaluations and they're doing minimal evaluations and hoping things, slide with it, right? So then they're getting hit with the IEE request. So what the whole point, my belief and my opinion is part of the reason for that prior written notice is for districts to allege that it is a situation, well, the parent was on notice that if they had concerns or things that they wanted to have more testing about or that they could contact the LEA and they didn't fill that out. It's trying to place more burden, and just so we're on the same page, this is not required by the law. This is not statutory. This is PDE made up requirements placed on districts. And I really don't think it's going to hold as much weight as PDE tries. PDE has tried this with the other form, which is the parent consents to not having testing done. Well, let me put it this way: even if parent consents to not having testing done or review of records, if the district is supposed to review or supposed to do testing and they fail to do to, they're still being held accountable. So, but the reality of the situation is this is an attempt to give districts arguments of, look, we sent the notice out to consent to the parent. They have the point of the form that they could have filled out for us to contact them if they were concerned about a kid's speech and language evaluation or speech and language needs or their behavior needs or anything like that, and the parent never filled that out. Okay, so that's why you're getting that prior written notice. So the district can now say, hey, look, we tried to talk to the parent about what they wanted for testing and they never communicated with us, and now they're coming back 6 months later and saying we didn't do testing when they never communicated with us about it. Okay, but again, this is not statutory, and so that's part of the reason I suspect this prior written notice is having to come about, so that it's a arrow in the quiver of the districts to say basically we shouldn't have to pay for independence. The reason for the change, and again, in my humble opinion, the change on the consent form is because the law allows that if the district has made reasonable attempts to get an evaluation of your child, and as long as you don't do anything to not consent to it, that they're able to go forward with it. The whole pendency in not consenting was usually 2 ways. Historically, mediation and due process. Now they've given another option for them to say, oh, we couldn't do the evaluation because the parent didn't consent because they asked for another meeting. So they're trying to put in there about that whole not ask for, I do not consent, which is that part 3 and the informal meeting. So you may just be thinking you're asking a question, but what you've really done, and just so we're on the same page, if you don't subsequently give consent, if you have marked that, and let's just play this out because you just see it happening. So let's say you go, I didn't know what this testing was, or I wanted to have an opportunity to discuss more about what the testing they were doing or what was going on. So I said I didn't want to consent because I didn't know what, that was going to entail. So I didn't consent. And I had the informal meeting, and then we had the informal meeting, and then I understood better. And I thought they would then go forward with the testing. But paperwork wise, guess what? They don't have to send you another consent to reevaluation after that meeting, right? Their paperwork now says you don't consent. If no evaluation takes place, they have legally given themselves an attempt to get out of jail free card, okay? And that is why this form is so dangerous for parents with kids with disabilities, because you may think that you're doing something because everything else, mediation and due process, guess what? Other people come in, the state comes in, the mediators come in, the hearing officers come in. You're aware that you've stopped the process, but simply asking for a meeting, you may think you resolved it. And just trust me, they will say, yes, we had a meeting. They didn't consent. They never followed up. We didn't move forward with the evaluation. So that is why that form, in my opinion, is really dangerous. The other one, I think, is just an attempt to, put more bonus on the district. Because I did go back and check the regs, because I was like, were the regulations clear that what consent meant? And it's not. It's ambiguous. It just says does not consent. It doesn't say does not consent and ask for mediation or due process. That was the historical interpretation. The difficulty is you will now have 2 forms that we have no hearing officer decisions on. So we don't know right now, as we sit here today, the implications of these forms. If a parent doesn't put into that, do I think some hearing officers are? I think we're going to have split decisions on that. And about the consent, I think that that's, again, going to be something that we're going to have to wait to see how this plays out. But these 2, it's funny how people, will see things like this and think, oh, there's PDA just changing its forms up. When the reality of the situation is that these things can have subsequent major implications for kids with disabilities.
Well, and going off, the moral of the story really is when you get the prior written notice for the reevaluation, the one that we're looking at now, the district is sending this, interestingly, the district is sending this to you to put you on notice. They're supposed to document the date that it was sent. There's no necessary way to actually track it. If they drop it in the mail, or they put it in your kid's book bag, well, we know how that all turns out. I mean, I was cleaning out my kid's book bag and I found birthday party invitations, and this was June and I found them from like September, October. So if it's going in the book bag, it's not going in the parent's hands. But reality is the triennial evaluations are due. But if you actually do receive one of these forms, the onus is going to be on the parent to say, I don't want just a review of records. That's what they're doing. Because the team could come back and say, well, we need more data. We need to do additional assessments. Oftentimes, at least in our practice, they'll say no additional data is necessary. They'll issue the reevaluation report within the 3 years without any new data. So if you actually get this form, you're going to, as a parent, have to take the next step and notify the district that you want a full comprehensive reevaluation. And then that will trigger the district issuing the next form, which will then outline the assessments that it's proposing. And then how do you get around the informal meeting? And we tell this to our families all the time. We tell them we consent. See, there's box number 2. Say on page 1 it lists, cognitive achievement, a functional behavior assessment, and assessments of social emotional functioning. They write that in on page 1 at the bottom there. You can actually check the box, I give consent, but add to that, I'm also requesting a speech and language evaluation. You can mark up these documents. Again, they're not set by federal law. This is a form that's prepared by a regulatory agency saying you should use these forms. So there's no reason you can't give consent, but also put on there what additional information that you're requesting. And you could also give consent and say, I'd still like to have a meeting. So there's no reason you can't mark up this form. But you have to be a savvy parent to know that. Because like Heidi was saying, if you check, I would like to schedule a meeting to discuss this action, or I do not give consent, and then you have that meeting, the district doesn't necessarily have to issue you another form and complete that evaluation within 60 days. If they don't do the evaluation, they're going to come back and say, well, the parent wanted to have an informal meeting. I never got consent to do this evaluation. You certainly want some sort of evaluation to be completed, because if the district does complete an evaluation and it's not comprehensive, the parents then have the right to ask for an independent educational evaluation at public expense, which means you ask the district, you tell the district, this evaluation is not comprehensive, and I'd like you to pay for one of somebody I choose, and they're usually, a couple $1,000s. So in any event, you still want the district to complete the evaluation. I mean, if you truly don't understand the process and you truly do want to have a meeting with the district and you check one of these boxes, then you're going to, at that conclusion of that meeting, you're going to have to document in writing that you're requesting it. You're either giving consent at this time somehow, or ask the district to reissue the consent form. The difficulty is when they reissue the consent form is they're going to date it from, after the time you had that meeting, and it gives them another 60 days. So from the date that they receive your consent. So you kind of have to be savvy with these forms and how to navigate them, because like I said, this first one is just a notice to you. You don't have to sign it and return it. So it's going to be on you to say, I want the consent form. I want a full comprehensive evaluation. And if it doesn't include all the assessments that you want, you can either, and I have clients do this too. You just email the district and say, I received the consent form. Can you add, these other assessments to that consent form? And a lot of times the districts will do that. So something to keep in mind as you're navigating these new consent forms.
And I will just tell you this, and the reason why we're so emphatic about this is that there are a couple get out of jail free cards for districts that when, even if they don't do right, it is very hard to hold them accountable for it. And not consenting to an evaluation, even if you thought, well, I just wanted a meeting, so I didn't consent. If you don't consent and they can walk away, putting the onus on you is not consenting, you can't then come back during that evaluated time period and say, well, you didn't do a good job, because there is in the law says that if you do not consent to an evaluation or reevaluation, you then cannot complain and seek compensatory education for the time period that you did. So, and again, the difficulty is it's all when we make these decisions as parents, right? We're all parents here. We don't make them with legal implications decisions. Although, let me just be candid with you. My kids, how we all see our kids' death everywhere. So we're like, don't go too close to the ledge. Don't get down from there, right? Because we see their deaths everywhere. I see liability and death everywhere. So I'm constantly thinking, don't do this. You could be sued. So my poor children now suffer from, liability as well as death, prohibitions. But this is one of those situations. So we don't think about that. And a lot of times when we're making these forms up, but when I tell you that this is an attempt to get situations so that they can limit parents' right to independence and limit parents' right to complain and pursue past compensatory education, it is. And the reality of the situation is this. Parents we do not go to, you guys are all that are here are doing the absolute right thing. You're getting yourself as educated as possible. But a lot of times we as parents, we just, assume everyone's working in good faith, right? They're schools and that everything is going along well and they're the experts. And that is where you get hung up, because there's this assumption in this law that you understand that by not giving consent, because I can tell you in every case, and I've had incredibly savvy parents, parents who are, cardiologists, very intelligent people, don't understand. I did not know that when I said I didn't give consent, I just didn't trust them. I didn't think they were going to do a good job. I was going to go get outside testing. So that's why I didn't consent, that you are still giving them that get out of jail free card. Because trust me, no one consents with that knowledge, but that is the reality of the situation. And that's why I think we just need to hit that part home.
That is absolutely true. I've had both situations happen. I actually went to a due process hearing for a student. The parent did not understand the evaluation process, simply asked to have a meeting to go and understand what the evaluation, the student was emotionally fragile, and the parent was concerned about what assessments they were going to be doing with this, new to the special education world, and just wanted to meet with the district. At first the district wouldn't meet, and then eventually they did meet. Months kind of went by until the school district had a meeting, and then discussed everything with the parent. The parent wanted to think about it. Eventually the parent consented. But when we went to due process hearing, the hearing officer concluded that the parent was not entitled to any compensatory education because the parent didn't initially consent to the evaluation when she should have. And then I've also had same thing. I actually had a very intelligent family. They were concerned the district, family was a doctor, felt that their child needed an evaluation, and they didn't want to wait the 60 days. They were concerned that their child needed help right away, and went out and paid for an evaluation on their own, and were able to get it done within a month, turned it over to the school district, and asked the district to develop a program based on the diagnoses found in this private independent evaluation. And the district, so we need to do our own evaluation. And the parent was saying, well, I have an evaluation, but the school district's saying, well, we need to do our own evaluation. So the reality is the school districts under the IDEA have the obligation to do the evaluation first. And if the parent doesn't give that consent, it's going to limit any remedies that the parents that may have available to them going forward. So I know there was some questions about behaviors, and I wanted to just touch on discipline, because in talking with other counsel for school districts as well as other parent counsel, we are seeing more and more and more and more behavior cases, discipline cases coming through our pipeline. And it's been since COVID, since schools reopened, we've had more issues with behavior than anything, and school districts are handling it, are differently. We can give a whole presentation on discipline, but I just want to touch upon it so that you just have an understanding that children with IEPs or 504s, I know we're talking mostly under IDEA, but kids who have IEPs, they have an extra layer of protection against suspensions and expulsions. And so school districts are trying to get away with that with some of the trends that we're seeing. So there's really, the schools are limited on how many days that they can suspend kids. They can do it, in one school year, they can do it 10 consecutive days, or max 15 per school year. Otherwise, it's considered a change in placement.
Jen, before you go on from that point, I think we need to put, and that is absolutely accurate. Here's though some things that I think that are happening right now that we all need to be aware of. One, districts are not always recording suspension dates. Okay. So that is something that if your child is suspended, you should be doing an email to the district confirming the suspension and asking for the paperwork in writing, okay? Because they're trying not to suspend them. The other thing too is the two things. They're also doing the half-day pickups, which is, hey, Susie's having a behavior problem today, come pick them up. That is still a pattern of exclusion, okay? Fourth is, and this was a hearing officer case that actually found that this was an exclusionary practice, is, well, we're not suspending him, right? He's just going to the behavior room and spending, and not in school suspension. He's going to the behavior room, and that's where he's learning for the day. If a child is segregated, and the hearing officer was pretty clear in this case, if a child is segregated, that counts towards that time, that counts towards that 10 days. So anytime a child is excluded for disciplinary reasons, regardless of what they call it, that counts towards that time period. So it is very important that parents, you are documenting that in emails to districts about the time period, because trust me, they are not documenting that in any capacity.
That is true. And you jumped to my next slide, but I'm just going to go back here quick because I want to talk about expulsions too. We've seen some expulsion cases come through. I would say we've seen the more pattern of exclusion more so and try to change their placement rather than going through an expulsion. But know that districts may not expel a special education student for a manifestation of that student's disability. So there's that they have to hold. There's, like I said, we could talk about this to give a whole other presentation on discipline, but there has to be a team meeting to determine if the behavior in question was a manifestation of that student's disability. And if it was a manifestation, they cannot move towards expulsion. And these protections are extend to those students who are thought to be eligible. In other words, those students who are suspected of having a disability, but may not have, they have not completely gone through the evaluation process. So these are the protections in place for these students. And then I talk about some of the trends that we're seeing, which Heidi talked about a lot of them. And I'm seeing the same thing, is it, you know, call, you know, the schools, we can't handle your kid, come pick them up. And that happens, and parents can easily document that. You know, parents are calling saying, I'm going to lose my job if I, you know, what happens if I don't come pick my child up? Then the school districts are calling children and youth services on families. So you're kind of in a no-win situation. I've seen school districts say, can you please keep your child home until we can figure another plan out? We'll send work home. Or let's do some virtual learning until we figure things out. I've had cases where, you know, if a student, they have, you know, they're in, you know, the autistic sport class part of the day, but they're supposed to go to their specials with regular education peers, or they're supposed to go to a math class with a regular education peer. And if they're having behaviors in their autistic support class, they're saying, oh, we can't take you to that other class because you're having behaviors. And usually the data shows that the behaviors aren't occurring in the other classes. We'll have school districts jump right to, we can't handle your kid, we need to change their placement right away. And all of these things that we're seeing right now, what we would consider maybe a denial of a free appropriate public education. Districts are required to do more than just call parents and say, come pick up your kid, come pick, you know, up Johnny or Susie, because we can't handle them today. I mean, there's certain emergency situations where if the child is a danger to himself or to other students, that's a different story. But, you know, all these trends that we've been seeing, or taking the kid from the classroom and having him do his work in the principal's office, that happens more times than we can count. So a lot of this can, if you can track it, if you're, you know, if there's somebody keeping a log, or if your child can come home and tell you what's happening to them during the day, you can keep track of that data. So options that, you know, we recommend.
Can we go back before we move on? Because I do think there's an important situation that it's funny because it came to me today when I was getting ready for Hot Topics. And one of the things that I was going to, you know, just touch upon is that there has been a steep decrease because of COVID in kids attending preschool. Okay. But in addition, because there's been a huge now, and kids who might not have been at the early ages, been able to participate a lot in socialization or going to daycare because parents were working from home, right? There is a large increase too in preschool, that 3 to 5 age range, in disciplinary procedures. And in Pennsylvania, most of the time, these kids are attending regular education placements, right? They're not necessarily and the supports are going in. If these kids are being kicked out of these private church preschools, there's really no plan in place and no one understanding. Parents probably aren't aware that if that child needs a preschool setting and their child has been removed from basically a private school preschool setting, then the IUs may need to be stepping in and providing that preschool setting for kids who can't be involved in a regular education preschool setting. Because the problem with the state of Pennsylvania, and trust me, case law is on the side of this. Kids are entitled to preschool, but the difficulty is IUs have forever gotten away with, oh, we don't provide preschool programming unless it's for very significantly involved kids. The parents pay for the preschool, and then we just infuse the services. But with kids being now kicked out of the private preschools, and it's happening there now, a lot of times it's just they have to bring in the kid to the IU, or the IU's going to the home environment instead. And that can't happen. That child is entitled to maybe not a significantly involved preschool room, but a more, you know, traditional preschool setting that parents need to start fighting for, because again, it is a real problem. And also just honestly for childcare purposes. And that's not a real reason to have it, but you know, there's a lot of parents who depend upon preschool as part of their, you know, childcare situation. And while you can't get programming for that, if you do need that as part of your child's FAPE, that was an important part of it. IUs can be provided and can be required to provide it. So that is something in terms of, you know, something that we need to be cognizant of. Also cognizant of the fact that the fact that there has been such a decrease in kids being identified in 3 to 5, because I think a lot of times parents kept them home. And, you know, listen, when you know, truthfully, we're in a pandemic. I don't necessarily, I'm not seeing my kid around other 3-year-olds to know that their speech delayed or that their fine motor isn't good. I mean, I don't expect to, so I don't know. So a lot of kids are also not being identified early. It was like a huge drop off. And so again, now we're going to be having these kids coming into school who've not gotten the early intervention, who now are probably going to have more significant behaviors walking in, and no one is prepared for that. So, and I know Jen's going to go on the next topic, but I do think us looking at preschool settings and the trends going there and those early ages is something that's going to be more on our radar screen than we're anticipating right now.
Yeah, that's a good point. No, the next slide is just some options, some things we recommend to kind of help navigate the waters of what you should be doing, what the things you should be looking for. Obviously, if you're getting the phone calls to come pick up your child, or if your child's having these, removals to other parts of the building, if the district's not proposing an IEP meeting, then you certainly should be having an IEP meeting to discuss your options. And when they're sitting there saying, your child's a behavior, then ask for the data. So I'd like to see the data. If there hasn't been a functional behavior assessment completed on your child, then ask that it be done. A functional behavior assessment is a tool that school psychologists and team members can use to track data of the child to see what's the function of the whole point of it is to determine the function of that child's behavior. And they'll collect data over the course of time and in different settings throughout the time period to see, is it happening during a certain part of the day? What's happening before the behavior? So they're looking at the antecedents to the behavior. Is it, it could be happening during a certain class period. So if they have not done the functional behavior assessment, ask that it be done. If it hasn't been done for a while, ask for it to be updated. And as Heidi said, track the time that, if you can, of your child that's missing time, because again, that could go towards the time that the exclusionary time, and you could also pursue compensatory education. And that's basically hours of lost education that your child was entitled to by his or her IEP, and the district's essentially taken that away and either sending him home or sending him to another part of the building, or refusing to allow him to be in specials or with a regular education peers. And one thing we need to know is districts may not change a student's placement to a more restrictive environment without trying other things. We call them supplementary aids and services. But basically, if a child's being bad for 2 or 3 weeks, this district can't just say, oh, we can't program for him, we're sending him out. You need to look at the continuum of placements that are available. Some counties can rely on supports from the IU. If your child's in regular education all day, you may need the support of a paraprofessional, or you may need to say, well, let's try, learning support, emotional support, or have them meet with a guidance counselor. There's other things that can be added to, other programs and support, other supports that can be added to the child's IEP before all of a sudden you say, yep, we're taking them from the district and we're going to put them into an approved private school. So, unless you've been trying for a period of time and kind of kept adding services to the IP and going down a more restrictive path, you shouldn't be taking a child from a regular education environment and putting them right into an alternative educational school or an approved private school. And we see that in some districts, it's easier for them to say, let's put you in another school rather than let's try to hire paraprofessionals, which is really what a lot of parents ask for. And the reason why is they're hard to hire. And we know that. It's hard to hire a paraprofessional. There's hiring, they're having difficulties hiring teachers. I just had a hearing where this autistic support classroom was basically manned for almost entire school year by emergency certified teachers who knew nothing about kids with autism. The paraprofessionals ran the classroom and did the best they could, while the other emergency certified teachers basically babysat the students. So you have to kind of know that you're entitled to more supports before the district tries to change your child's placement. And if they're trying to change the placement, they really need to be doing an evaluation, because the regulations say before you decide to change the identification or the placement of a child, they need to give you notice, and they really should be assessing the students. So you can be asking for a comprehensive reevaluation if one hasn't been completed. Just because the regulations say the evaluation's due every 3 years, doesn't mean you can't ask for one a year in or 2 years in. You can always ask that the district redo a comprehensive evaluation to determine that child's level of need.
And so one of the things that I think is really important when we're helping parents or we're advocating is to have a really easy mindset of like how to address behavior, because oftentimes you walk in a room, you're being deluged with all these different incidences that happened and what happened next, and every teacher or staff member wants to tell you the tale of the behavior problem, right? And so it's hard. So one of the things that OSIP actually did, they've been doing this discipline discussion blog where they really talked about, because it's an issue. I mean, let's just be candid, it's a real issue in districts. And they really talked about 5 constructive ways to address behavior. And so I think it's really important as parents and as advocates and attorneys that when we're looking at this, we kind of break it down, because again, unfortunately, I'd love to tell you that the leadership on the other side of the table is going to do it, but they may not. The first step is you want to adopt a preventative mindset. What does that mean? That means the first thing we should be looking at is not necessarily what to do when the behavior happens, but our first step should be is how do we stop the behavior from happening? Do we offer sensory breaks? We want a preventative attitude mindset. That's our first goal. The second is to examine data. If we're all sitting around the table, and I'll give you an example of my own kid, back when he was in 2nd grade, and he's graduating, he's in college now, so he's moved on. But she was like, he's off task all the time. And I said, all the time? She goes, all the time. And I said, well, is that like every minute of every day? Or like, and she's like, well, no, but it's a lot. So the problem is when we use those feelings of how it feels to us, it may feel like all the time, but it may not be. And so really, if you're having discussions at a table about behavior, it really needs to include data. And if they don't have the data, that should be the next step. We need to start collecting data, because the reality is how we feel or those expressive words that we have may not be accurate. Because let me be candid with you. If you have an emotional support teacher saying that the kid has no issues, but you have a regular education teacher saying the kid's never on task, that's because the emotional support teacher may be dealing with a lot in her classroom and maybe not notice it, or it may be more normal to her. Because again, we're all individuals, and that's a very subjective. Data is very independent. So you want to examine data. 3 is then to create the support systems and offer support into it. So when we have the behavior situations, what are we doing to create a support system for it? And we want those to be done as 4 evidence-based practices. We want to be looking at what we know works, what has been, seen in the industry, because for example, I am in a district right now that their behavior management plan is to make the emotional support classroom, make the kid basically work its way out of full-time special ed. So, and then by that, I mean, if you behave, you get to go to lunch. If you behave, you get to go. I know, trust me, it is what it is. We're having to shift their mindset. They really think that's the appropriate approach. And the reality of the situation is that's not what evidence tells us. That's not what the research tells us, what really works to change behavior. And the 5th is they recommend contacting OSIP, but the reality is contacting PTAN. If the team itself are at a loss, that's not when you go, well, guess we'll just have to ship them someplace else. Bring in outside resources, bring in PTAN, bring in other, medical assistants, bring in, Sinclair and the family-based services. It should be a team of do an interagency meeting, but it shouldn't just be, oh, well, that's it. So again, those 5 mindsets, when you're sitting at a table, I think gives you a chance to, instead of just having to be on the receiving end of the monologues of, all the bad behaviors, it gives us a real strategy to say, okay, we can't change the behaviors of the past. How are we going to address it going forward in a really constructive manner?
And I just wanted to touch upon this. If you find yourself in a situation where the district is trying to change your child's placement to more restrictive and you're opposed, you do have options. You can reject the NORAP and you can request mediation, or you can actually file for due process. And you have to do this within 10 days of receiving that NORAP. But as parents, you can file for mediation or due process. There's forms that you can just fill out. The forms are on ODR. ODR is Office of Dispute Resolution, for those of you who don't know that acronym, but you can actually just fill the forms out on your own. But you can actually go to mediation on your own. You can go to due process on your own, or you can hire attorneys. Attorneys are now can go to mediation, where in the past they couldn't, but they can go to mediation, or they can represent you at a due process hearing. But if you do that, if you file for due process, the district can't change your child's placement. So it buys you some time, because there's timelines that are built in. You have a little bit of time because then we call that pendency. So if the district issues the NORA changing your child's placement, you don't agree with it, you request mediation or file for due process within 10 days, the district can't change your child's placement. The district, of course, has to agree to mediation. But so if they don't, then you'd get notice and you'd have to then file for due process. Or if you go to mediation and it's not successful, then you still may have to file for due process, but it buys you a little bit of time to figure that out. But they can't just say, have a meeting, and then all of a sudden they're yanking your child and putting them into a school that you're vehemently opposed to. You do have options under the IDEA. So just so you know that if you find yourself in that kind of a crisis situation. There's other available remedies under the IDEA. If you go to mediation or due process, you can be pursuing compensatory education for a denial of FAPE, which we've been talking about this whole time. You can be asking for an appropriate program placement. If you end up pulling your child, which we get a lot of those cases, and paying for your own private school, you can pursue the school districts for that tuition. You can also pursue the school districts for out-of-pocket expenses that you may have spent. And certainly the IDEA is what we call a fee shifting statute. So your attorney's fees can be covered if you end up going to due process and you win. So there's lots of available remedies, by using your procedural safeguards. And parents hear, due process, and they're nervous and scared about it. And I understand that, but it is available and there are lots of options. And I can tell you, I know parents don't like to go to due process, but school districts don't either. They would much prefer to be able to work it out. So if they really do want to move your child to a different school, more often than not, they're saying, hey, we're moving him to this school. If you know that this program's not working, you can always go back to the district and say, look, I don't agree with this school, but can we agree to this other school? And you can kind of utilize that to your advantage. They're concerned they can't program for them. They don't want your child there because they don't have the support, but maybe you do know of a school that will work out better for your child, and you can propose that to the district. So just because the district is laying this out on the table, like, hey, this is the school we're picking, doesn't mean that you can't have input into it and say, all right, fine, I get that this may not be working for my child, but hey, how about we use it, try a different program. So these are just some of the available remedies that we pursue in all these situations, these behavioral situations. And I know we have till 8 o'clock, so we have.
Yeah, Jen, I had one more topic I wanted to talk about.
Oh, yep,
and I know that we weren't able to, unfortunately, connect, so it didn't make the PowerPoint. But one of the things that did come out, OSEP has promoted as a new resource for parents, advocates, and school districts it's called CITES, and it's the Center on Inclusive Technology and Education System. And the situation is one of the things that we have seen a lot of, and I say in and out of schools, virtual learning, right? A lot of times now kids are learning virtually even within schools, right? In terms of Chromebooks, but also you have virtual academies. You have kids who, like we've talked about, when they're on discipline, they're going to go to the virtual learning program of the district while we wait placement. And the reality of the situation is virtual learning is not very inclusive, right? It does not really look at how do we make this program available to be included for kids with disability. And CITES is a situation where that is something that provides a lot of support and resources. And they actually looked at and partnered with a school in Glen Mills, I think it was Great Valley, and other programs within the state to really figure out how to do practices. So there's a lot of great resources and information, because I'm going to be 100% with you. This is not necessarily one of those things where the districts are saying, no, we know what to do and we're not going to give it to you. I don't think districts know how to do it. This is brand new to them too, so getting outside information and going into it and them saying, well, we don't know how we can do that. If you give it to them or learn more how to do it, you're going to be a better advocate for your kid. And again, it's something that OSEP is promoting. So from my perspective, that is something that's been vetted through some pretty good processes. And again, it's called CITES. So if you Google CITES Inclusive Virtual Practices, it'll come right up as the first website.
I can actually add a slide to the PowerPoint with that information and then send it over.
Yeah. So I think there were some questions, correct? So the first one I see, what if the data is collected seems that the behavior seems inappropriate? Let's see. What if the data that is collected seems about the behavior seems inappropriate? Collecting data on too many things are possible to collect. Okay. So here's the tenets of good good data collection. It's called ABCs, right? And this is what I'm looking for when I'm looking for data behavior. What happened right before the behavior? Why is that important? Okay. It's called the antecedent. That's why it's the A. Because one, if we know that the child's being asked to read, or he was interacting with a peer, or there was a discussion about, whatever it was, we can start to figure out what the triggers are. But we can also start to figure out what we're doing is, listen, any idea that your child suddenly explodes with behavior is inaccurate. There's always a buildup of emotion. You can see them getting, twitching, or, getting up and not sitting down as much. And we're trying to figure out much as before that behavior's happened. B, what the behavior was, with very concrete language, not, inappropriate. Well, what does that mean? How were they inappropriate? Very concrete behavior. And then the consequence. What happened as a result of that? And I don't mean what the negative, was he suspended or sent, but really, what did he escape the work? Was it a situation he was sent to the principal, so he wasn't asked to do it? Was he sent home? Because the dirty little secret, sometimes those kids are not dumb. And if they know that they act up in school and then mom comes, picks them up, and they get to go home, and they're not liking school very much, that's not such a bad little deal for people. So again, figuring out, so you're looking for the ABC data. If it is not, and then the question is like, let's say you're dealing with so many different behaviors, right? You need to target, and really tier the most dramatic, because the idea that you're going to extinguish all behavior with everything is just inaccurate. So you're looking at creating a situation. What are the top 3 behaviors that we really have to be targeting right now? And you let the other ones go. They're going to exist. Like, let's say it's, not completing assignments. Well, okay, we may need to do that secondary if our primary is that he's running out from class every day. We have to tier them of importance. So you want to tier the behaviors and then collect correct data on ABC data. So hopefully that answered the question.
There was another one posted in the chat. In the scenario where special education settlement agreement is in place until age 21, what would be the process to extend that agreement until age 22?
Contact the district and ask for it to be extended to age 22. And just FYI, that would need to be in writing, because I'm in every settlement agreement I have ever been involved in, there is a provision that says modifications have to be in writing. And so what you want to do is send to them and say, do it in an email, and make sure that anyone you're talking to on the phone sends you an email back, because listen, there's a lot of turnover. And even if Mrs. Foster agreed, if it's not in writing, and now Mr. Smuckers is there, Mr. Snuckers knows nothing about it, and it doesn't exist.
And I think the difficulty is, I think that if, as parents, if you ask to extend the agreement versus going through counsel, I think my gut, we haven't had the situation yet, but my instincts tell me that their own counsel, their special education counsel, is going to say that there was a waiver in place. As part of that agreement, the request to not seek any more educational services from the school district, regardless, they use the age 21 because that's what the law was at the time. My sense is that they're going to probably put up a fight about it, because what was negotiated as part of the settlement included any future services, period, regardless if it's through age 21 or 22. So while certainly any modification of a settlement agreement needs to be in writing, I think that's going to be an uphill battle on that one.
And that's why, Jen, and I completely agree with you. And I think that's why I don't suggest necessarily getting attorneys involved off the bat on that, because if you call the district up and they're just agreeing to it in writing, and you might get it through because they may not know anybody, they may not run it past their legal counsel. So it's better to do, again, I think that is done much better through parental or advocacy versus an attorney. Right. The attorney's probably going to shut it down. Yeah.
Once an attorney gets involved, their attorney gets involved, and their attorney is going to say, well, why should we? This was a negotiated settlement for our past as well as future services, or whatever the waiver included, regardless of the change in the regulations. So if a parent hires a district, you may get a special education director that says, well, the law changed, so all right, and allow it to happen. That's my recommendation.